First of all, many thanks to Paolo and his colleagues for organizing this conference. It's already our second time here, and we are delighted to be here. It's great to have lots of experts exchanging views and ideas in this highly technical field, but challenging and interesting, so many thanks to you. We are going to talk this afternoon about private antitrust litigation, and I am also deeply honored to be joined by three distinguished experts. I should not introduce them to you because I think most of you already know them, but I will nonetheless briefly present them to you in alphabetical order. To my right, you have Riccardo Penisi, who is a senior lawyer of counsel with Simmons & Simmons in Italy, who has been involved in several proceedings before the Italian Competition Authority, but also the Administrative Court, Council of State, and he's also regularly intervening in private antitrust litigation. He has also been working for clients and representing them in proceedings before the European institutions. He has a very wide experience, very broad experience regarding matters on cartel, state aid, abuse of economic dependence, unfair practices. And Riccardo also teaches competition law, and you are one of the founders of the association Concorrenze. To my left, you have Alberto Pera, who is an honorary partner and founder of the Competition and Regulation Department at Gianni Origoni. The law firm he joined more than 20 years ago. Alberto is well recognized, not only in Italy, but also abroad. He's also represented many very large companies from Italy in cases and proceedings dealing with competition law matters. Alberto is also the chairman of the Associazione Antitrust Italiana, and you were from 1990 until 2000 Secretary General of the Italian Competition Authority. And with your experience, you shared it already with the broader public by publishing several books and articles on these matters. And last but not least, to my far left, Professor Carlo Scarpa, Professor of Economics at the University of Brescia. Carlo has a PhD from the Bologna University and a PhD from Oxford University. Carlo has taught at University of Bologna here in Italy, but also currently, I think today, still at Brescia. And he has been collaborating and giving lectures in prestigious foreign universities such as Oxford, Cambridge, Johns Hopkins, the London Business School, and l'École Normale Supérieure de Paris. So as you see, we have all the experience and expertise we need to discuss about private antitrust litigation. My role here, well, as a moderator, my background is litigation funding. Deminor has been active for more than 30 years. In Italy, we are close to 2 decades of activity in Italy, and in the field of antitrust, we have been funding litigations since 2016, so around 7 years of experience in this particular field. We have offices throughout Europe, in New York, Hong Kong, so we always have a global approach to litigation and to funding court action. I think as a funder, and this is why I have the role of the moderator, as a funder, we are very close to the position of a victim out of an infringement of competition rules. And then as often a group, whether it's a large corporation or SME, confronted with whether it's a cartel or an abuse of dominance, you wonder, what should I do? Should I do anything? And then how should I do it? With whom? And how do we deal with the aspects of costs, risks, time? So we are very practical. I mean, we deal with litigation, it's about the law, but it's mostly about practice. We know that being able to rely on an existing decision, which is the typical follow-on claim, can facilitate the decision to litigate, but it's not a done deal. It's never a done deal. There are many steps before getting to a recovery. So a funder, just like the plaintiff, the client of a law firm or of an economic expert, the funder must have a holistic view of litigation. And so to help us better identify and understand the opportunities and challenges related to private antitrust, we must rely on experts like the three members of the panel today. So as I said in introduction, we have been active for close to 2 years in Italy, and if there is something we learned, it is that when in Rome, do as the Romans do. So dear Alberto, Carlo, and Riccardo, we are looking forward to hearing you explain what we should do if we want to properly litigate in Italy. And now, starting the discussion right away, as you understand, we will focus on Italy. I think tomorrow there is another panel discussion about Europe, so the broader context of private enforcement in Europe, but today it's about Italy. We are in the eternal city, Roma, so let's talk about Italy. I'm sorry I cannot do it in Italian, but let's talk about Italy. So the way we structure the discussion is as follows. It's a bit like economic experts do it with their quantification of harm. It's the before, during, and after. So here we will do it with before the litigation, during the litigation, and then the path leading to the after the litigation. So the first stage is actually, as I said, I'm like a corporation, or I'm a funder, I want to fund litigation, or I want to start my own litigation, I will self-fund it. But what should I do? When do I need to take action? And if you agree, Riccardo, I will start with you. In your experience, how can companies in Italy know or verify that they have been harmed by a cartel or an abuse of dominance? And do you see them often wondering, okay, but is it worth for me to take action as an SME or even as a large group? What about the losses? What are the pros and cons?
Yes, I would like to start thanking for the invitation. So thank to Deminor. Going to your question, I think that like everything in the antitrust enforcement in Italy, things are developing quite fast. We notice that companies are now very much on it. They check decisions. Trade associations are monitoring, and keeping aside, of course, consumer associations that we know that have been very active in pointing their fingers right after a decision of the competition authority. Would it be an antitrust decision or would it be consumer protection decision? We've seen this happening. As far as companies are concerned, I think that, again, there is not a general rule. It very much depends on the violation to start with. And, of course, abuse of dominance, certain abuse of dominance have certain impacts, might have certain impacts. Cartels might have an impact. It very much depends on the conduct, of course. But keeping this aside, it is important to understand before, you have to ask the question, is it worth, as you were mentioning? And I think that the only way to answer that question is making some homeworks, which means studying understanding what might have been the impact. Relying on assumptions wouldn't work, probably. We are seeing this. So I think that it is very important that companies that are monitoring what happens at the Italian Competition Authority or at the Commission or wherever, they should think about, is it worth? Because being a purchaser of a product would not necessarily be enough. It very much depends on many other circumstances, so you would need to understand the level of purchases to start with, using a very simple example, of course. And then trying to understand, again, what is the impact. And on that, my personal perception is that having an economic consultant at an early stage would help also to take the decision. Then, of course, and I'll then stop, because Charles is staring at me, but of course, then you have also to understand options. One of the main issues have been the cost of litigation, but on this I think, and this has typically prevented small, medium enterprises to start actions, and have also had a significant impact on, I have significant purchases. Are them significant enough to face a litigation? But on this, I think that we will, discuss later on.
Correct. Thank you, Riccardo. Alberto, I know you have been mostly taking sides with the defendants in most cases, but what are your views on this?
Well, thank you. Well, we have a very strong public enforcement department, so obviously, generally, we are on the side of those who are on the bad side of bad people's side in the antitrust decision practices. But but one has to point out that at least in Italy, the field of defendants and plaintiff lawyers is not as defined as would be, say, in the United States. So there may be cases in which you could be involved in a plaintiff case, and this is particularly true not so much in cartels, even if in cartels it is always possible that you assist a company which has been hit by a cartel, particularly in raw materials cartels. But on the other hand, but particularly in abuse of dominance cases, because abuse of dominance cases obviously have relation. But now, this issue of cartels and abuse of dominance, commenting on Riccardo, makes a difference in terms of how you prepare to the case. Why? Because usually in cartels you know that there is a cartel because an investigation starts. You do not necessarily know who the parties are, and in any case you must get information about it, and you must do what Riccardo was saying, a sort of due diligence or investigation of how this cartel which comes out may have affected you, and probably the fact that you belong to an association, you have relations with other parties helps, and obviously what he was suggesting would be relevant. In the case of the abuses, usually you know very well what's going on, and you have the information and so on, and you may more easily evaluate what is the damage you are taking. Actually, very often it is you are one of the parties of the investigation. In terms of what you what you should get in terms of information, perhaps we can get to that later, but the before is very much related to the during, in the sense that at the end, what the information you gather are the ones that in the proceeding will help you both will be needed, let's say, both in terms of legitimation, for instance, both in terms of damages. But think what happens when you have a long cartel, And in order to claim damages, you must have information about perhaps 15 years before and so on, and that's obviously creates problems.
Correct. But that's, I mean, thank you for this, Alberto. It makes it easier for me to then reach out to Carlo, because we've heard Ricardo saying as well, it's all about estimating what's the potential value of my claim. And if I have a contract and the contract is not performed, usually you know what I can claim in court. The challenge with infringements of competition law, it's hard for a non-expert to know, well, how much? I remember very often people ask us, yeah, but how much can I claim? Because I don't know. It's not like money was taken away from my bank account and then you see there's a drop on your bank account. No, you paid for something, but you paid too much, or you were squeezed out of a market from a dominant player. So, Carlo, can you please tell us how to solve and how to address, from a practical point of view, the importance of collecting evidence and information, and what the cost could be?
I love clients, and I hate them at the same time. In this period, I've been working in this area many times on the defendant side, sometimes in more recent years on the plaintiff side, many even more times on the court side, the court-appointed expert, the CTU. And it's always complicated to get the right data. It's always, it is as if you are torturing people. You know, and I understand that, because sometimes you tell a firm, listen, probably you have been damaged because you paid too much. And it is as if you are insulting their buyer. Saying, okay, you were unable to buy at reasonable conditions, and therefore, by saying that you should have paid less, I'm accusing you. That's not the case. Obviously, when there are cartels or things like that, the story is totally different. But at the beginning of a case, it is fundamental to convince firms that if there has been a violation of the law, they have been victims of a violation of the law, not of the inability of their buyer. Getting all the data can be complicated, as Alberto said, because for a firm, data of 3 years ago are history. Nowadays, in Italy, we are talking about cartels that started at the end of last century. So we are talking about violations that have been going on for more than 20 years, and so if not an economic research, it's a paleontological research from a firm's viewpoint, which is really difficult. But so you have to do two things. First, a rough assessment at the end, at the beginning, of the amount of purchases. And then there must be some understanding by the court, which that it's absolutely correct that they must insist to have all the data for recent years. They must turn a blind eye on old data. Otherwise, these cases are never going to be pursued, and the private enforcement in Italy, if one can wants to be extremely precise about data of 20 years ago, these cases are not going anywhere. So we want to decide whether we want to have private enforcement seriously in Italy or not. Then the initial assessment can be a problem, because it really depends on what the data allows you to do. There are data that allows you to have a market-wide assessment of the counterfactual. So basically you have a typical econometric during and after, or before, during and after analysis, in which you have all your nice data, and you say that during the cartel period, all prices in Italy were higher by X%. Or you must have or the data doesn't allow you to do that, and then the data allows you to have firm-specific assessments, which is much more complicated. It really depends on the nature of the cartel, the nature of the existing data. And that is much more complicated because aggregating in the second case can be a more delicate issue, can take more time. It still has value, but we'll talk about that later. But certainly it is more complicated to have an initial assessment of the damage. It really depends on the nature of the cartel, on the nature of the data available. So at the beginning, one must make a huge effort to gather all the data, especially for recent years, turning a blind eye on old years in which you can have rougher estimates. And again, either you allow that or you kill the private enforcement in Italy. That is, that must be said with extreme decision. And I believe the private enforcement makes sense, but different criteria must be applied for different periods of time.
Okay, thank you, Carlo. We'll come back to that later in the during litigation and even the preparing the after. Alberto, we heard, I've been hearing since the start of the discussion, all three of you talking about the time it takes to reveal an infringement, then the time it takes to find the data, the time it takes to prepare the litigation, then we also have the uncertainty of, well, what if the decision of the authority is being challenged before the courts? It can add a lot more time. How do you see it? Do you consider that how can we reconcile the need that Carlo just explained now, said, okay, we need to rely on the data, but some of it may already be lost, with all the uncertainties related to the administrative proceedings, and how would you consider this? How would you deal with it? Because it looks like you have to go fast, but it's always delayed.
Well, as a defendant's, mainly defendant's lawyer, I would say, let's take time, okay? But given also what Carlo was saying, and the need to ground your request on solid grounds also in terms of information about past data, damages, and so on, I think that it may not be so bad to have, in cases even of follow-on, to wait time also for the plaintiff. Aside from abuse of dominance, where you need interim measures and so on. But let's consider the case, basically, which is basically in cases of follow actions. And because you need to study the case, and you must to provide the information, you must to gather. So, and the fact that the decision becomes final, so there's no possibility of appeal, is also an element which obviously helps the plaintiff. Obviously, there are different cases. There are cases of settlement where the decision is immediately proof and immediately implies that the conduct is there and damage is presumed. Different cases when you have appeals. But generally, even if you have a settlement case, it will take time to set all the information and all the elements which are necessary, including, say, access to documents and so on. Obviously, the defendant has an interest of delaying things, and so the appeal to administrative judge, usually to the administrative judge, is something which which is, first of all, is due, if it is possible, because it may lead to. And generally, judges give suspension in cases of this, up to as long as it is the ordinary appeal case, i.e. to the Council of State, not in cases of, for instance, revocation or cassation or something like this. Now, I know that it is, I mean, the plaintiffs sometimes resent the fact that the judge suspend the decision. I mean, I took some time, I make an action, the process has started, why should you suspend it? However, an argument that judges raise, and I think is not such a bad argument, is, and it is related also to the conduct of judges in other matters, is an issue of efficiency. Because what happens is the authority's decision is quashed during the appeal. Then a follow-on action becomes a standalone action. And a standalone action implies an activity which may then be subject to limitation, which may be precluded according to which stage the judgment has arrived. So there is a cautious attitude generally by judges with respect to request of suspension because of recourse to the administrative judge. But I don't think it's reasonable.
Ricardo, what is your experience in that field? And then maybe all you and the others, could you share your own experience or thoughts on how do corporations tend to respond to information about there is an infringement? Do they take action rapidly? Because law firms or even funders, sometimes they will reach out to potential clients and say, you know, you should take action. But do you see them being responsive, being willing to really start and not wait for the very last moment until it's almost time barred? Ricardo.
Yeah, actually, what I've seen often is that clients prefer to wait. They prefer the certainty of the case. They also want sometimes not to be the first movers. Whether I do share this view is another story. What is sure, going back to what Carlo was saying, is that waiting shouldn't mean doing nothing in the meanwhile, probably, because collection of data is relevant. The longer you wait, the more likely is that some of those data are lost in space. Then another point that is linked to this one is that the link with the leniency program, because we have seen that, leniency applicant normally, they do not appeal. We've seen this in a case on the financing, automotive financing, that there was this threat of litigation, massive litigation on that case. Then the Italian Competition Authority didn't resist, but interestingly, the Italian Competition Authority has on its own motion, well, not exactly on its own motion, but has itself annulled its decision for the leniency applicant in order to prevent any sort of inconsistency and preserve the life of the leniency program, because of course the link between leniency and follow-on actions is crystal clear. There's no need to stress it here. So I think that the tendency is wait. That clients are normally preferring to, be sure that their efforts are based on solid rock in terms of, a final decision at least that has been upheld by the, if we're talking about Italy, by the Consiglio di Stato. Then, of course, there is also the point of, the suspension that is something that those that do want to move, they, as Alberto was saying, they do not like. But it is also true that for efficiency reason, it makes perfectly sense to me.
Carlo, from your perspective, do you see the same thing? Is it also wait and see?
Yes, and there are other reasons, also commercial ones. Firms fear a retaliation from their suppliers. They don't like to be the first one to lead, the first knight that leads the troops against the enemy. You're the first one to be shot. So you better wait, you better build a critical mass And when the critical mass is ready, okay, let's start moving together. I start making a move, and then I look back how the others following. There is this aspect. Obviously, then the authority will vigilate that this retaliation does not take place, but it's not always easy to monitor that this does not happen. Moreover, I agree with what Alberto and Riccardo were saying. I mean, I put it more bluntly. The judges don't like to work, and so they don't like to work twice if it's not strictly necessary. I work with judges and don't tell them. But anyway, there is no hurry in starting. Obviously, there is the issue of not letting the deadlines expire. That is, that goes without saying, but I'm not a lawyer. I'll let the lawyers deal with this. But certainly there is no hurry starting. There is also because entrepreneurs are entrepreneurs, and they tell you, listen, my value proposition does not go through courts. My value proposition goes through building products that have a market and making a profit out of those products. Then, do I have to defend my rights through a court? Yes, maybe. But my main business is something else. And I respect that. You know, I like entrepreneurs because of what they do and because they don't think that court cases should be a major part of their value proposition. But I think that times are changing, that now people are getting more and more used to the fact that these private enforcement cases must be pursued. And so even this country is changing, slowly, but it is changing.
Okay, thank you, Carlo. Moving now to during the litigation, so the structuring of the court action. You've said, and I've heard from you, there's an issue with momentum and there's an issue with critical mass, and this is where the collective litigation comes into play. We're not going to talk about the specificities of a class action versus a bundling of claims versus an assignment of claim, but let's talk about more broadly grouping claims that can help create momentum. It can also create economies of scale. Litigation funders, although they tend to fund single individual claims, if you present a collective action to a funder, you actually present a higher volume of claims, meaning it can be more interesting in terms of investment. But first, who has to deal with this? It's the courts. Alberto, how do judges in Italy see these grouped claims? Do they consider it as beneficial, or do they have a more nuanced view? And do you think we can already draw some lessons based on the last years?
Well, I would resort to the last argument of Carlo about judges. I don't take it the way, I don't interpret it the way, but I would say...
Okay, it was slightly provocative, I admit that.
I try to be kinder. No, the real point is that judges are obviously interested in saving time and in preventing duplication, okay, or complication. So this is reflected, therefore, in their attitude with respect to, at least from what we have seen, on collective, say, group actions, because these are not really collective actions in the technical terms. They are grouping of individual claims which are grouped together, and they refer usually similar or homogeneous products, and therefore this makes sense. Obviously, this from the defendant's point of view, this is not necessarily a good thing, because obviously you defend better when you may operate on the specifics of the case, but judges are usually favorable to this, and I may add they are also favorable to the call of third, say, by the defendant, which, because of solidarity, obviously, usually tends to call other parties, and judges are usually favorable to this, despite exceptions sometimes, because they think that this prevents following action in regress. So if the question is what's the attitude of judges, I think that it is relatively favorable on this ground.
Okay, so we may count on the support of the courts, which is already something. Riccardo, according to you, what are the benefits for the plaintiffs, and maybe, I mean, it's maybe more for Alberto, for the defendants, but we can also hear from you whether you think they see benefits, whether they prefer to have one grouped claim against them or have to deal with hundreds of individual claims.
Well, the issue is distinguishing then among the claims, because when you have the group, then you try to see the position of each, obviously in front of the judge, even more in front of the cortex, to the expert appointed by the court, and there you may see that you may try to disentangle position in terms of then definition of the damage and the pass on and so on.
But that could mean more costs as well for the defendants.
That's true. But usually, well, that's true, but obviously it is a cost benefit for the defendant, okay?
Okay. Now, Riccardo, the plaintiff's view, what are the benefits for plaintiffs? And would you say that group actions are actually only for smaller claims? Is this true?
Nope, I don't think it's true. I think it's what we see, but I don't think it's true. Then I'm here, you know, I have the part of the plaintiff, just the plaintiff, but yeah, I will keep it. In any event, I think it's not for small claims only. I think that grouping claims might be well perceived by courts, as Alberto was saying. Another point that Alberto was making was, you know, distinguish the various points. You know, also psychologically, you know, the amount of the claim would be higher, certainly. However, I would also turn to what Carlo said about the complexity of aggregating, and that's the other side of the story, because of course you have to prove your damage, you have to gather the evidence, you have to collect a lot of data. Then it very much depends on how you want to proceed on that, because presenting probably a full, detailed position for each and every claimant would be very difficult, let's say, at the least. So you have to take some decisions on how you want to proceed, and of course some decisions that should balance, you know, having an effective way of proceeding, but still having a sound analysis that would be credible to the court. So these are the main topics, I think, that relate to this. Also, getting back to what you initially said, it is clear that smaller claim and smaller claimants might not start the action in any event in case they are not grouped, and in case sometimes they're not funded. So that is another part of the story. That, of course, building the case, increasing the volume would, you know, attract probably, and we've seen this in Italy, attract funders, and that would, of course, be a sort of, you know, the wheel that is start turning.
Okay. Carlo, according to your experience, I know you've been, you're an expert, you're party expert, but you've also acted as a GTU. What do judges usually expect from the plaintiffs in terms of documentation, economic arguments? I mean, are they, if a plaintiff comes and say, "Oh, look, there is this Oxera study, average is 20%," how do judges react with this?
Well, I think they have their garbage bin ready. I think that the judges, from what I've seen, want to have the plaintiffs make every possible effort to support their claims. Then normally they understand that certain things are possible, other things are impossible or anyway unreasonably difficult, but certainly they want them to make an effort. It doesn't mean that everything must be tailor-made to the single plaintiff. Recently, I was a defendant in a case, which Paolo probably remembers because we were on the same side, in which the plaintiff basically won the case with an estimate of the damage which was, technically reasonable and so on, but had very, very little to do with the specific situation of that specific plaintiff. It was a fairly general analysis that could have applied more or less to anybody, but still a court ruled that effort was sufficient to show that there had been some kind of damage. Okay? So certainly the usual documents, invoices, budget, and all the statement of accounts and so on must be produced. The analysis must be there, claiming that some court in another country has come up with an estimate. Okay, can be good to support your argument, but doesn't lead you very far. And this is it. Notice that in terms of aggregation, there are. I'm usually convinced by numbers. When I looked, one of the big cases which goes around in Italian courts and keeps us all busy in different roles is the truck cartel. I had a quick look at Wikipedia. That you know how many transportation companies, autotrasportos, on wheels company were there in 2021 in Italy? 99,415. Do we want 99,415 different court cases on the same cartel? I mean, okay, divide them through, 3 specialized courts, 33,000 cases in Milan, 33,000 in Rome, and same in Naples. That would be crazy. I mean, you don't go anywhere with this. And there is another issue that goes in favor of aggregation, done at the beginning or during the case, whenever it is possible. It's called the law of large numbers. These estimates are not easy. If you make an estimate on the basis of the observation of 40 trucks that you have bought, it's one thing. So the variance of the estimate can be huge and the reliability of the result can be very limited. If you have 20,000 trucks all put together, that becomes a totally different story. It's true that when you put together different companies, different plaintiffs, you introduce heterogeneity into the sample. Heterogeneity is not always bad, because at the end it allows you to have an estimate which probably is more reliable than one that you may obtain on the basis of very small samples. So there are bad things about aggregation. Obviously, one can always say, well, this estimate is not precise. There's very little to do with the specific situation of the plaintiff. True, but statistically, aggregation is usually synonymous of strength of the data.
Okay, thank you. We're getting close to the end of this panel, but I think it's time to go to the soon to be after the litigation. If I can stay with you, Carlo, what is the role an economic expert can play assessing a client involved in settlement negotiations? Because you've helped the client and the lawyers of the client substantiate the claim for damages in court, but how is your role any different? How would you approach the opportunity of a settlement where you need to find a way to say, okay, you know what, this settlement proposal is reasonable, you should accept it?
Tot capita, tot sententia. A lot of different heads lead to different positions. I've seen cases in which a client asked me to support him to the very end of the negotiation. I've seen cases in which the client said, well, okay, thank you very much, now it's my time, it's my moment. But I've also seen situations in which the client said, okay, now is my moment, but at the end of the day, he called me up and said, listen, do you know what I obtained through this transaction? Well, I obtained exactly the sum that you told me I should have got. Obviously, then you inflated because the possible claim in other directions, but you told me that those were weak, but what you said was right, has been acknowledged by the other part as something robust. So I think that there is a sense in which solid economic analysis makes sense, even in negotiations, even if we know that negotiations are a commercial moment in which, soft skills may prevail over hard facts.
Okay. Now, assuming it doesn't work, there is no settlement possible. Alberto and then Riccardo, how do you see judges approaching this? In Italy, I'm talking about Italy, will they say, oh, I see hundreds of pages on the one side, hundreds of pages on the other side, they all say exactly the different things? Is it like with the cat saying, oh, you claim 10 and you claim 0, okay, so it's estimate 5? Or is it, oh, let's see what they do in other countries, so it's not do as the Romans do, but it's more, oh, do as the foreigners do? How would you see judges in Italy approaching this? Okay, no, it's my role. They have not come to a settlement. I need to decide.
The judge will have a court-appointed expert, and the court-appointed expert will make an estimate of damages. Obviously, not necessarily gives its own just a number, may give a range, and this may pose the judge the issue of deciding within the range, but the judge will not generally estimate. That's not what he should do. He should make a decision, an equitable decision, according to the code. It's difficult, it's probably impossible to have a precise estimation of the damage, so the decision may be based on equity, but on the basis of actual data which are provided by the parties, or since the court-appointed expert is there, by the court-appointed expert. Then the judge may reason about this, but that's the basis. So I don't think that, say, a 5% of cut or else would be relevant for the judge.
Okay, so Italian judge will not be influenced by what others say. They will.
A judge is a judge, so they takes its autonomous position as relevant.
Okay. Riccardo?
No, on that, my comment is that I fully agree. I mean, Italian courts in particular would, in my view, very unlikely, take for granted positions that have emerged in different systems, in different scenarios. They, of course, like their job to a certain extent. They want to do it autonomously, and it's, in my view, quite unlikely that they would be somehow, directed by positions that have been taken in different jurisdictions. So I would, the 0, 10, so we stuck at 5, okay, we've seen this in the UK and we'll use it in Italy, wouldn't fly, in my view.
Okay, and one final question for all three of you. do you see private litigation, well, private antitrust litigation on the rise in Italy? In other words, as a funder, should I come more often to Italy?
Well, Italy is a beautiful country, so I think it's a good idea if you come. In addition, there may be also good perspectives.
Well, Italy is a great country, always a strange one. Now it looks as if it's certainly on the increase. If likely that it will keep going in this way, but it's also a country full of surprises, so keep your expectations low, but positive.
Yeah, no, I think it is true. It's raising somehow, and I think that, you know, the more you come in Italy, the more it will increase probably, but also very much depends on, you know, standalone actions are far more complicated. It will also very much depend on the enforcement trends of the authority. There are certain cases that are more suitable than others to start, you know, a flow of litigation. So it will, you know, maybe very much depend. But as Alberto was saying, you should come in anyhow to Italy.
Okay, point taken. Thank you.